Hi, this is Jim Cunningham, and we're going to talk about what is trust administration and do you really need a savvy lawyer or a savvy attorney? Very interesting question. Do you need a lawyer or do you need an attorney? What's the difference? And do you really need this involvement of the lawyer or attorney in a trust administration? What is trust administration? A lot of people, by the way, this is a terrible word. Lawyers use it all the time. People have no idea what it means. Trust administration, what that just means nothing, right? So a lot of people are confused. And we're going to talk a little bit about the difference between an attorney and a lawyer. So a lot of professionals, a lot of lawyers don't actually, or attorneys don't think there's a difference or don't think about it, but we intuitively know there's a difference and we talk about it, but without kind of being obvious, which I'm going to be with you. What are the different roles? What does a lawyer do? What does an attorney do? And they're fundamentally two different roles. And what are the responsibilities of a trustee? So whether you need to hire a lawyer or not, you need to understand the scope of what you're getting into. So if you're the trustee, there's a lot of stuff that you are going to have to do. If you're the beneficiary, you're kind of along for the ride, right? It's kind of like, I don't want to say like being a baby, but, baby just kind of sits there and eats and does whatever they do and cries and kind of what beneficiaries do. They're not doing a whole lot. It's the trustee who has the laboring or who's doing all the work. The beneficiaries are kind of along for the ride. So not only will you, by watching this, not only could you potentially spare yourself enormous hassles and errors, but working with the savvy attorney or lawyer greatly reduces your personal liability as successor trustee. So that's one of the things we'll be talking about is the liability of a trustee. And spoiler alert, it is 100%. You're 100% liable for everything you do, everything you don't do and you should have done, everything you screw up. And, you might get an attaboy or a pat on the back if you do something well, but it's kind of a one-way ratchet. You're basically punished in a lot of ways and really, frankly, not rewarded much. Can you be paid? Yes, we'll talk about that. But being a trustee is kind of a thankless job. So I'm Jim Cunningham. I'm your speaker. I'm a partner at Cunningham Legal. This year, it marks my 30th year as a lawyer. We have offices throughout California. I'm a certified specialist in estate planning, trust, and probate law. I'm also a real estate broker, securities, and insurance licensed, and a pilot. I'm not current. I'm a third-generation pilot. These are the lawyers in our firm. Our firm is completely dedicated to the sort of the peaceful transfer of wealth between generations, minimizing taxes and drama and protecting assets for loved ones. And if you're watching this on YouTube, we do these live, but we do post them on YouTube. Go ahead and subscribe to the YouTube channel and give us a little thumbs up and hit that bell. And you'll be alerted by hitting the bell. You'll be alerted when we post our content, which is typically Thursdays at about 6 p.m. And we do that regularly once a week. I'm a lawyer. I'm talking. My lips are moving. Words are coming out of my mouth. Please do not take this as legal advice. It's a little bit like the disclaimer in Shark Tank. No one's offering you anything by watching this, right? So just because I'm a lawyer and I'm talking and looking at a camera does not mean that there's an attorney-client relationship. This is information only. So let's talk about what is the difference between an attorney and a lawyer. Interesting question. Frankly, not a lot of lawyers think about this, and you can hear the term I'm using, lawyers. Some people say, well, I'm an attorney or I'm a lawyer. So what is the difference? Well, both are educated in the law. Lawyer is kind of Middle English roots. It means someone who's gone to law school, passed the bar, and it can also be descriptive of training and licensing. But here's kind of the fundamental difference. And we have a graphic here. If you're watching this on video, there's an example of a lawyer who's meeting in an office with clients. So a lawyer is dispensing legal advice to a client. So that is the function of a lawyer. And, the context here is, of course, if you set up your living trust, and we'll talk about what a living trust is, you set up your living trust, you meet with the lawyer gives you advice, drafts documents, walks you through the documents. That's lawyering, okay? That is the dispensing of legal advice. Attorney means something a little bit different. So a lawyer is dispensing legal advice to a client. An attorney is French in origin, which is attorney from the French, meaning one appointed or to arrange. It's Old French, Middle English. And it comes from the Latin attornare, which means to turn over to another or one appointed or constituted. So attorney at law is not only trained and educated in the law, not only is that person lawyering, but they're also representing a client in a given situation. Now, this could be a court situation. It could be an out-of-court situation. So in this context, if you are the lawyer is the consultant and the advisor, and the attorney is somebody who's representing on behalf. So what happens in a trust administration is you actually have both. So the lawyer will be advising the trustee on what to do and what not to do. And we'll talk a lot about that in the materials here. And also the attorney can represent, right? The attorney can represent the trustee in dealing with third parties, in dealing with, a jerk brother, right? I hope you don't have one of those. But that trustee could be a family member, and they may have a disgruntled sibling who's causing a lot of problems. And as I was getting ready for this, I was speaking with one of the paralegals in her office, and she was telling me, I had to deal my own personal situation. I had to deal with a step parent who got married right before my parent passed away, and all these new people ended up with everything, and it was terrible. So that's a situation where you would need an attorney, perhaps to go to court, right? But you would need an attorney to represent the trustee, potentially beneficiaries as well. But it's important to note that many lawyers, or attorneys, many lawyers will have an office practice, and other lawyers will have a court practice, and that would be like an attorney. So the attorneys would have a court practice, typically representing clients in court, and the lawyering happens in the office. So that's a good way to think about it. But with trust administration, it's a little bit of both. So, and this is really important. Although a living trust is, I would say, organically or natively designed to stay out of probate court, and if there's something going on internally with a living trust, it is probate court that the trust goes to, right? That the trustee goes to. Trusts often end up in court for many reasons. So sometimes you simply run out of trustees. The person you named as your successor trustee, we'll talk about what that is, but a successor trustee is someone who serves after you. That successor trustee may not be alive. They may say, I don't want to do it. Well, all trusts have to have a trustee. So if you don't have a trustee, a lot of times you're going to court. Now, if you have a trust protector, we cover this in other materials on our YouTube page. If you have a trust protector, that's something that can keep you out of court. Assets not being titled in the trust. I would say that's very common for clients to set up a living trust and transfer title of the house to the living trust. And then they go and get the property refinanced, right? Maybe they have a mortgage. The property comes out of the trust. Person dies, that property's outside of the trust. What do you do? Well, you have to go to court to get that property back into the trust. And trustees seeking the court's protection from hostile inheritors. These are, the technical term is beneficiaries. So this is someone who gets the benefit of the trust. Again, this is the person who's along for the ride. The trustee is the adult in the room. The beneficiary can be the big baby and say, I'm going to be a stinker. And they kind of can do that, frankly, under California law. I'm not recommending if you are a beneficiary, you be a stinker, but it's something to understand as trustee. You kind of have to be the adult in the room and be the responsible one, even though this person may be acting unreasonable. Sometimes trustees want to go to court to be protected so they're not sued later, right? After they hand over a bunch of money to the beneficiary goes out and hires an attorney who takes that trustee to court, right? You want to make sure that you have that nailed down. Sometimes there are ambiguities in a trust document. These might be poorly written trusts or changed circumstances. So either, and so this is one of the problems of a short trust, a trust that's 8 pages versus 80 pages, 80. A trust that's 8 pages may have some inherent ambiguities because it's just not long enough. So to terminate or otherwise modify an irrevocable trust. So meaning that maybe a situation's changed. People say, gee, well, the way that trust was written, everyone agrees it shouldn't be written that way, and let's just tweak it a little bit. That's something that typically does require court involvement when a person's passed away. So if you think any of these above sort of things we've talked about applies in a given case, that's where the role of the attorney comes in, because you are going to court. The trustee really should not be representing themselves in court. Many courts I've seen prohibit a trustee from representing himself or herself. Certainly in a probate, that can be the case. It's not always, but it's very important that the trustee really should, if you're going to court, a trustee should be represented by an attorney. So what is a living trust? It's very important to talk about what a living trust is. So a living trust is a lot like a bucket. So this living trust is a bucket that has a handle, right? The trustee holds onto the handle. Now, a trust obviously is not a bucket, it's a document, but I'm trying to give you a visual here. So a trustee is kind of like it's a holding tank, right? Things go inside the bucket. So when the trustee stops being trustee, that bucket handle passes to a successor trustee. So when people, you might hear people talk about, well, who's the successor trustee? So if you talk to a lawyer, who's the successor trustee? Well, you're like, what does that even mean? That means the person who comes after you, the person who's not currently serving as trustee. So if I'm trustee and I have a living trust that names a successor trustee, when I stop serving trustee, the successor trustee becomes trustee, and we remove the term successor. So the successor trustee oversees the trust bucket of assets without a probate court. This is really important because living trusts are designed to provide a benefit. A trust is designed to provide a benefit to a beneficiary. Probate exists to pay creditors. It's very important to understand. The reason probate exists, the reason we have this very complex system in California and incidentally in New York, is not to protect people who inherit. It's to protect people who have lent money to a decedent and they want to get paid. So that's really the structural difference between the two. And minimization of taxes. Trusts can oftentimes be written in a way to minimize taxes. Other benefits include protection from an inheritance. So a lot of people, they say, look, I want my kids to inherit. I don't want my future ex-sons-in-law and future ex-daughters-in-law to participate in that inheritance. Now, you might like your son-in-law or daughter-in-law better than your own kid. That's always a possibility. But I think most people say, no, I want to keep this in the family. And if there's a divorce, I don't want it going to a future ex-son-in-law or ex-daughter-in-law. And predators, this is for people who may not be able to manage money well. That's always a concern. Some people say, well, this person just won't manage money well, and they're going to need this pot of money to live. And I got to tell you, I'm in California, very high cost of living. And many people want to make sure that their children and grandchildren have a source of income, quite frankly, so that they can continue to live in the high cost state of California. So even if you make a lot of money in California, sometimes you're going to need a little bit of extra to have to have a life. Living trust, significantly better than probating a will. So if you're on the fence, if you're like, gee, I don't know about this living trust versus a will, I would say in the vast majority of cases, a living trust is going to be better, regardless of the size. It's because the way trusts are constructed is they are to provide a benefit to beneficiaries. Probate, again, is to provide a benefit to your creditors. So living trusts can be used for estate planning, for tax planning, for asset protection. Tax planning is an interesting one. That's where we often see a lot of irrevocable trusts. So a living trust is a revocable trust. So what this means is while the person's alive and mentally competent, this is a revocable trust. If you talk about an irrevocable trust, that's one that's not subject to amendment or revocation. And many of these trusts, by the way, so if you're the one who's creating this trust, you might create a certain irrevocable trust for a tax benefit. Many instances, you're not even the trustee. So you're not in control, and maybe your family's a beneficiary. And there's a reason why we do it that way. We cover this in other materials in our on our YouTube page. But sometimes you're not the trustee on a living trust. Typically, you're going to be the trustee if you're mentally competent. So again, trust can be used to avoid probate and provide a legacy for loved ones, minimize taxes, and manage assets for beneficiaries who are minors or who have special needs. And I would say living trusts are the core of most estate plans in California. And really, this provides the person who creates it peace of mind knowing that they've done what they need to do to preserve their legacy. Because when you leave this earth, and as we all do, you leave this earth, all of your stuff stays behind. All this wealth, you may have spent a lifetime accumulating wealth and worrying about it and caring for it and protecting it. Well, when you're gone, someone else is going to get that. You can't take it with you. So a lot of people want that peace of mind to know that what they've spent a lifetime accumulating and protecting is preserved for the people that they love and care about. So what is a successor or future trustee? Again, this is not you. This is a person named in the trust to manage or an air quote here, administer the trust. Administer the trust to carry out the terms of the trust as written. A trustee cannot deviate from the terms of the trust. Very important concept to understand. Very rigid in the sense that a trust has to be carried out as written by the trustee. So the trustee is the one carrying that out. A trust protector, on the other hand, again, we covered this in other materials. A trust protector can modify certain terms of the trust to conform to the intent of the person who set up the trust. Let me say this another way. Sometimes we set up a trust based on certain factual assumptions, based on certain laws. And as time goes by, those facts change, the laws change, and the way the trust is written is not exactly carrying out the intent of the person who created the trust. That's when a trust protector can come in and modify the terms of the trust. Otherwise, you're going to court. You're going to probate court to have those modified. A lot of people don't like that. They want to keep it out of court. I would definitely, court is the last place in many instances you want to go. So you're definitely a good idea to keep it out. So responsibilities of a trustee: carry out the trust terms of the trust as written. Marshal, which means, get your trustee's name and all the assets that the assets should have the trustee's name on, marshal the assets and manage them, and follow applicable statutes, case law, and doctrine. Now, we're going to talk about this a little bit more, but just because you have a trust and you're the trustee, that is not the whole story. So you have a trust that says the trustee shall do this, this, and this, but there's a lot of other statutes, and guess what? They're not necessarily in that trust. There's a lot of other stuff a trustee has to do, and those instructions are not contained in the trust. This is very common for lawyers when they create an estate plan for a client to not include a lot of this other statutory language and duties. It's just the way these are written. So you have the statutes that say, probate code section, blah, blah, blah. Trustees have to do these things within a certain period of time. If a person passes away owning real estate, you have to notify the assessor's office of the change in ownership within a certain period of time. And case law. So you have the trust, and then you have a statute, but you might have case law, which is a court decision that says, well, if a trust says this, we're going to ignore it. Or if a trust doesn't say these things, we're going to insert these other requirements of a trustee. Rarely do beneficiaries have any sort of penalty for doing stuff. There is a no contest clause. It's been really watered down in California since 2010. And basically, beneficiaries largely are free to make the trustee's life miserable, quite frankly. And there's not a whole lot in many instances that the trustee can do other than hire an attorney. Remember the difference between a lawyer and an attorney to talk to the jerk beneficiary, right? To say, look, I'm done talking to this jerk. You got to talk to my lawyer. I'm just don't want to deal with you, right? I'm done. So doctrine, what is doctrine? Well, doctrine isn't really it's not what the trust says. It's not a statute. It's not case law. Doctrine, it might be a series of cases or a concept that comes up. And doctrine is something that judges will apply in a particular case. Again, this is like after you go to court, or the lawyer will advise the trustee in the course of the trust administration. I realize the trust says this, but this trust was written before this certain date, so these terms don't apply anymore, and the court will apply this doctrine, right, and apply this case law to, frankly, change what the terms of the trust say. So this may be really disconcerting for you. You say, well, this is ridiculous. This trust was written in 2015, and this case came out in 2018, and another case in 2019, and now there's this doctrine that says the way this was written in 2015, the trustee can't carry out the terms of the trust as written. Yes, it's because there's case law and maybe other statutes or doctrine. So it's really important. So this kind of answers the question, does a trustee need to hire a lawyer? Well, you don't know until you know, right? And that's why it makes sense to have at least an initial meeting with an attorney, really a savvy lawyer, to sit down and say, hey, like, this is what's going on. This is what the trust says. Am I missing something here? Do I need to hire a lawyer? And we do this quite a bit in our firm, where in our firm, people will reach out to us for the specific purpose of finding out, do I need a lawyer or not? And guess what? In some cases, if you're the only beneficiary and your mom had $10,000 in the bank, you might not need a lawyer. All right. A lot of people that we help, in fact, the vast majority of people that we help need a lawyer because it's more complicated. They might have real estate, they might have jerk beneficiaries, they might have other assets that drive more need for a lawyer or an attorney. A trustee also has to communicate with beneficiaries. There's the inheritors as well as other people. So on a very high level, trustees have duties, beneficiaries have rights. Which would you rather have, a duty or a right? Well, I'd rather have rights because it means I don't have to do anything and I'm getting something, right? As a beneficiary, I can just sit back and be the complainer, as I mentioned. So trustees have to do a bunch of stuff. Beneficiaries can sit back. Trustees cannot be jerks. All right, if you're a trustee, don't be a jerk. You can't be a jerk, right? If you're a jerk, you might be removed by a court. You might be held personally liable, which means you might have to dig into your own pocket and pay the jerk beneficiaries some money. right? Beneficiaries can be jerks. And just because a beneficiary files a court action, what is a court action? It's filing documents at the probate court level. Just because a beneficiary files a court action does not necessarily mean that someone has challenged the trust. So many trusts have what is called a no contest clause. The no contest clause says, beneficiary, if you file a trust contest, you get nothing. Courts abhor a forfeiture. That is a maxim of law, right? That is something we learn in law school. Courts abhor a forfeiture. Courts do not like to say, oh, you did this thing and now you get nothing. Okay. Now, does it happen? Yes. Do judges like to do it? No. By the way, there are no juries in probate court. So in California, you're not going to get a jury trial for what we're talking about here, internal affairs of a trust. You're not getting a jury trial. It's a bench trial. So you have one judge, and that person is going to come to the case with their certain point of view. And it's very important to be mindful of that. And it's a really good idea, frankly, to stay out of court, right? So if you're kind of, the big takeaway here is like staying out of court's a really good thing. And that's why it's really good to consider a trust protector. Again, I've mentioned this a couple of times. Trust protector can sometimes help you stay out of court. All right. So what is a trust administration? What does this mean? This sounds like doublespeak, right? Trust administration. People kind of get a glazed look when they hear that term. Trust administration is the process that a trustee follows typically after the death of a grantor, which is the trust owner, the person who created the trust. Now, trust administration can happen upon incapacity, but fundamentally what we're talking about here is when somebody passes away. So a trustee has to identify trust property, meaning what is in the trust. You can't just sit back and do nothing, right? Take control of trust property. A trustee has an affirmative obligation to take control of trust property. So typically it's going to be recording documents at the county recorder, evidencing that the trustee's passed away and there's a successor trustee. Might be going to financial institutions, removing a deceased person's name using a death certificate and using the trust itself, maybe a certificate of trust, managing the trust property, right? So making sure that, it's appropriately invested, distributing trust assets, right, to the people who are to inherit them. So there are a sequence of things that have to happen. You can't just start identifying trust property and then distributing it right away. That's a little helter-skelter. It's not necessarily a great way to do it. There is an ordering of things, and it does take several months at a bare minimum, I would say. So if you're a person who's thinking, well, gee, how long does this take? I would say minimum kind of 6 months in most instances for a variety of reasons having to do with the trustee's duty to notify everyone who's named in the trust and everyone who would inherit in the absence of a trust. And again, this is something that is not contained in the trust. It's an absolute duty in the state of California. And you have to give people 4 months from the date that you served them with this notice. You have to give each person 4 months to come forward and challenge the trust. So it would be foolish for a trustee to distribute all the assets prior to that 4 months being up, because the trustee has no method of getting the property back to give it to the rightful beneficiary. So you got to be really careful on that. In most states, including California, if there's no trust, you've got to go to probate court. And I would say in general in California, the probate fees run 4 to 8%, and that's 40 million or 40,000 on $1 million estate. It's a little bit closer to 50,000. Attorney fees can consume an entire estate. How is that possible? Well, if you have a $970,000 mortgage on $1 million property, that lawyer's still getting their fee, and the beneficiaries will get nothing because the fees are set on the gross value of the assets, not the net value of the assets. So it can consume a lot. Now, how do most attorneys charge for trust administration when you're comparing it to probate? Probate is a percentage of the estate. Most attorneys that I talk to charge an hourly basis for the trust administration. So some people do a flat fee. We find that that's really not fair all around, and fundamentally an hourly engagement is a better way to go. So what is a trust administration lawyer or attorney? What are they? So when a trustee seeks legal advice, they do so from a lawyer. So the lawyer is typically the one dispensing legal advice. And when it's time to go to court, that lawyer many times represents the trustee in court, sort of takes on that role of being the attorney at law, and dispenses advice as a lawyer, but also represents the trustee as an attorney. So sometimes the trustee says, hey, the decedent had this bill and the creditor's kind of nasty, and I really don't want this creditor to have my phone number and my home address. Lawyer, can all the communication go through you? That's an example of the lawyer performing his role or her role as an attorney, so representing the trustee with respect to a creditor. So that might be a reason, if there's some creditor issues, that might be a reason, if you're a trustee, why you would want to hire an attorney, is to represent you and kind of shield you from them having your cell phone and your home address, and all that goes with that. So some trustees get in a bind and some even legal trouble because of lack of awareness of duties. So there are a lot of duties that a trustee has. They are contained in the probate code, in probate code section 16,000. So if you Google probate code 16,000 duties, you will find lots of duties that a trustee has. And many times these duties are enumerated, or they're listed or recited in the trust itself. So oftentimes, trustees work with a specialized law firm to administer a trust because these firms have the experience and resources necessary to adequately advise the trustee. And I will tell you, this is the purview of specialists. And if it's a generalist lawyer, or maybe a lawyer that does a lot of estate planning, but that lawyer doesn't do a whole lot of trust administration, that can be problematic. You really do need someone with experience. And there are a lot of people out there who do estate planning as lawyers, and they really don't know how to administer a trust. So this is kind of the dirty little secret in law. Many people are setting these things up, but they don't really know how to administer them. Why do I know that? Because when I started practicing 30 years ago, I learned how to do estate planning. I had no idea how to administer a trust. And when I did trust administration starting out, there were a lot less rules. There were a lot less guidance. So that was 30 years ago, right? And I'm telling you this from experience. When I became a lawyer at the tender age of 25, I remember one time a client said, "Jim, I have socks that are older than you." So, but it does help to have an experienced lawyer, and the lawyers who handle trust administration in our firm and the paralegals who handle trust administration are very experienced professionals. So working with a law firm, not necessarily, and I use the word choice here carefully. So working with a law firm, now in our firm, we have lawyers and attorneys, right? So that role, that licensed role, and we also have paraprofessionals. We have paralegals. It's very important that in our firm, we use paralegals. They bill at a lower rate than the attorney bills at. Many times they get the job done quicker than the lawyer does, right? So the lawyer is pushing down as much work at the lower billable rate to the paralegal, and that keeps the overall fees down. And it's really important in our firm to keep the fees down because we tend to have happier clients, and we're by definition adding more value. So we're very focused on operational efficiency and keeping those fees down, keeping the value high, but keeping the overall legal cost on the lower side when it comes to trust administration. So why else would an attorney work, or why else would a trustee work with a law firm or a lawyer or trust administration attorney? Because trustees have 100% personal liability. What does this mean? That means a trustee is 100% personally liable, out of his or her own pocket, has to reimburse a trust if they fail to do something, or they do something they shouldn't have done, or maybe they missed a deadline. This happens a lot where trustees really oftentimes don't know. And if you don't know what you don't know, that's really a danger. There's a term in aviation called the coffin corner. When you hit a certain altitude and a certain angle of attack, you're in a really bad spot. Not knowing what you don't know is a really bad place to be as a trustee. And that's why it's really important to reach out and get some legal counsel, whether it's a lawyer or an attorney, to find out, hey, am I missing something as a trustee, or what should I be looking out for? What are these sort of, to me as a trustee, what are these unknown unknowns, and let's make them known unknowns. So at least you know what you're dealing with a little bit, and knowledge of your gap. So knowledge of how to properly execute the wishes of clients in trust documents. The trustee, the attorneys for the trustee will be able to fully advise the client who's the trustee. Look, this is what the trust says, but then you also have this case law and statute and doctrine. And oh, by the way, this changed about 5 minutes ago. So we're up to date. And I was, in fact, just getting ready for this today. I was reading a new case that came out recently that has really impacted the no contest clause. So this stuff is changing all the time. Cases coming out all the time. And the attorney may need to represent the trustee in probate court to protect people or protect trust property. So meaning the trustee primarily, or trust property itself. So What's the number one reason why trustees should get a lawyer or attorney? The number one reason is 100% personal liability for everything that goes wrong. If something goes wrong and some beneficiary gets less money, that trustee is liable to make up the difference, 100% of the difference. This is found in the trust itself. So what's the liability? What are the do's and don'ts? It's found in the trust, the probate code, court cases and doctrine, probate code section 16,000. We talked about that. That's where all the duties are. Different rules applied in capacity. So this is one thing that people, if mom's not doing well and you're helping mom out and you say, well, I'll put my name on, I'll be co-trustee with mom. There's a whole new set of rules that come in. And I would say one of the things that can trip people up is there's an ordering of liquidation. So if mom's incapacitated, mom can't do for herself. If you have an asset in trust, or maybe a POD account or a joint account or a bank account that's in trust for somebody else, or other assets maybe held in mom's name, there's an order of liquidation. And if you liquidate incorrectly, you are liable. So what do I mean by this? Well, mom has 100,000 in the bank, 100,000 in a joint account, 100,000 in her name, and maybe 100,000 in an account that says, hey, when I die, it goes to so-and-so. You're going to have to drain each account in sequence, not just take money out of each account. That's where I'm going with that. So that is called order of liquidation. These rules are arcane, cryptic, and they can be very counterintuitive. So you might think, well, this makes sense to do it this way, but it's actually the opposite. So, you're just not going to know until you talk to that lawyer. So this would be an instance where not knowing is really bad. And the reason they're so arcane and cryptic is this goes back to the first crusade in 1096. This is almost 1,000 years ago. This is when trust first originated. And we cover this in another webinar, but so we have almost 1,000 years of law on this. So this is one of the oldest bodies of law, and really it doesn't make a whole lot of sense. So the insider tip: seek out competent, savvy legal advice. This is not a do-it-yourself project. And this is really important to understand. In the last year or so, we're recording this in January of 2024. In the last 6 months, stocks have gone up. They went down, then they went up. So if a stock goes down, and if an individual stock goes down in value, that trustee is potentially liable for the entire drop in value, right? Unless a trustee has an investment policy statement or investment policy memorandum. So this is what's called an asset management plan. This shields the trustee from liability. So if the trustee has a written plan, and we help trustees with this, I have this portfolio of $5 million, all these different stocks. I'm not going to sell these stocks, or I am going to sell whatever the plan is. You just have to have a plan, right? And that can shield the trustee from liability. So very important if you have a stock portfolio or other assets. I would say other assets that are subject to more volatility and have a readily ascertainable value, like a publicly traded security, right? You know at any instant what that thing's worth. That's where you would want to have your investment policy statement. So what does a trust administration lawyer do? What do they do, right? What do they do that maybe a trustee can't do? This is part of, like, should the trustee even hire a lawyer? Like, how are these people going to help? Like, what's the value that they're adding? The value that an attorney adds is they determine, and I will tell you, in law, they say that every piece of real property is different. And what comes to mind is like a condo building with like 500 one-bedroom condos. Yeah, each one of those is different. Theoretically, they're different, but we kind of know that they're kind of all the same. This is not the case with trusts, okay? With trusts, every single case is going to be different. And the reason is you have different combinations of people and different combinations of assets. Things happen at different times. So it's almost like an infinite number of potential combinations of facts. So these really have to be taken one at a time individually. So the lawyer determines, meeting with the trustee, which tasks should the trustee perform and when. And this formulates the game plan. And again, each trust is different. So if a trust has real estate, you're going to have some extra tasks. If it doesn't have real estate, you're not. If a trust has an interest in a closely held business, maybe it's a family business, you're going to have a lot more tasks to do. And it's really asset driven. If they're minor beneficiaries, there's a little bit more work to do. If there's a beneficiary with special needs, a little bit more work to do. You can see it depends on the type of people who are inheriting, as well as the assets and the way the trust is written. So, and that you communicate the plan to the trustee. The lawyer typically writes a memo or some other instruction letter to the trustee saying, these are the things you need to do, and assists the trustee in collecting assets, paying debts and taxes, and distributing assets to beneficiaries. These are the people who inherit. Also, what's really important is when a person passes away, we typically get a valuation of assets. What do I mean by that? So one thing that's really important is if it's a married couple in California and that married couple owns community property, married couple or registered domestic partner, as to California capital gains tax. But if you're married, you get a full adjusted basis for federal and state purposes. Well, what does this mean? If you have a couple that bought a house 25 years ago for $100,000 and it's worth $1 million today, that house can be sold by the surviving spouse for $1 million and not pay any capital gains tax. This is not true for registered domestic partners in California or unmarried couples. Registered domestic partners do get a California adjusted cost basis. So you save the California tax, but not the federal. That may be a case potentially for getting married, but you really have to be careful. The difference between registered domestic partner and married in California is registered domestic partner doesn't disrupt typically your federal Social Security benefits. That's the kind of the big deal, or other federal retirement benefits, but something that really should be well researched before you jump into it. But understand, very important to have that asset valued as of the date of death, because if you're the surviving spouse, you can sell that property for $1 million and not pay any capital gains tax. If you wait 2 or 3 years, you're going to want that basis adjustment, right? That wiping out of several $100,000 in capital gains tax. And this includes real estate, marketable securities. So you could have $100 million in Apple stock that you maybe acquired for $1 million. You're wiping out a lot of capital gains. So that property will never be taxed in terms of capital gains tax if it's structured properly. Closely held business interests, that's a little trickier, and other assets need to be valued, oil and gas royalties, collectibles, those sort of things. Typically, a trustee will create an inventory of assets. So the 3 major steps are identify trust property and get it in an organized manner, pay debts and expenses, and make distributions. So creating an inventory of assets. So this is typically a list that says these are all the assets that you have. Now, the implication is if it's not on the list, the person doesn't have it. So this is really important because someone might say later, years later, hey, what about that condo in Hawaii? And you'll have your inventory saying, yeah, they sold that a year before they passed away, so it wasn't in the estate. So you won't have somebody questioning you, a year or 2 later that could cause a real trouble for the trustee. So it's good to have an inventory. You start with that, and that's something the attorney typically helps with, and then facilitating coordination with other professionals, CPA, certified financial advisor, real estate appraiser, those other professionals. So a lot of times and again, if the trustee is very organized and they say, you know what, I can handle this stuff, just tell me what to do. Sometimes the engagement's like that. Other people come in, they say, oh my gosh, I've been married 50 years. I lost the love of my life. My brains are scrambled. I can't handle this. I know it's important. I need a lot more help. That's fine too. Yeah. Are the fees going to be higher? Yeah, probably, all things being equal, but the job will get done. And it really depends on where that person is mentally, frankly, because this is, within the context, someone has passed away. And this can be a period of significant grief. And if you've lost somebody, my heart goes out to you. My father-in-law recently passed away, and he passed away a couple of years after my mother-in-law passed away, and it was really hard on him. So they were married for over 60 years. So I get it. Sometimes you're not thinking with a clear head. So what about debts and expenses? You got to identify debts. Must debts be paid? Interesting question. We have a whole webinar on this, on covering debts. Sometimes and sometimes not. And this is why you may want an attorney, somebody acting on the trustee's behalf, dealing with the creditors. Because the creditor says, hey, is there any money in the estate? And you're the trustee. You're like, the lawyer can say, I don't know, I'll get back to you, right? So, dealing with the debts, probate has a different structure than trust administration. With probate, an executor has an affirmative obligation to notify creditors. A trustee does not have an affirmative obligation to notify creditors. So creditors have the right to come in and make a creditor's claim in probate. In a trust administration, the creditor, it's a much bigger lift for the creditor to actually get paid from a living trust. Does not mean that living trusts provide creditor protection. I'm not suggesting that. But what I'm suggesting is that that structure, it's a lot easier for a creditor to get paid. If there is a probate, it provides that creditor a forum to get paid. Secured versus unsecured debt, meaning a mortgage is an example of a secured debt. A personal loan is an example of an unsecured debt. Secured debts are typically going to be paid, right? That's something that even with a living trust, if you sell a house with a mortgage on it, you're not going to get clear title unless you extinguish the mortgage obligation. How do you pay debts? Do you pay them from do you pay them from what's left over? Do you pay them from, if somebody leaves a house with a mortgage on it to somebody, does that person take the house with the mortgage or not? Well, it depends on what the trust says. What if the trust is silent? Depends on what the law says. What if the law is ambiguous? It depends on what case law says. You see where I'm going with this. It really is case specific. And what if a debt is disputed? What if somebody says, I think I'm owed 500,000 and the trustee says, I think you're owed 100. What do you do then, right? That's where you need an attorney. Does it make sense for the trustee to contact the creditors? This is a hot topic that we discuss quite frequently. Does it make sense to affirmatively reach out to the creditors? I would say it's a case-by-case basis. Last illness, funeral, and expenses, disposition of remains, those should be addressed, and typically those are paid. Ongoing bills, mortgage, taxes, insurance, you got to keep those current, right? You got to keep that mortgage current, otherwise the lender will foreclose. Trustees can get paid if the trust instrument provides for payment. How much are they paid? Again, we cover that in another webinar. Some counties allow a certain percentage. Most counties, I would say, are saying you got to track your time and submit a bill. Some counties are completely silent, and so that doesn't help. So again, we cover this quite a bit in other materials. Can the trustee hire a lawyer or an attorney, right? And who pays that? Well, it's a very interesting question. You might say, well, that's pretty obvious. This is what we're talking about. Should you hire a lawyer? Well, there are two situations. First situation is where a trustee is acting in that person's capacity as trustee of a trust. If that trustee uses trust funds to hire the lawyer and later that trustee stops being trustee, the privilege, right, the attorney-client privilege transfers to the successor trustee. So the privilege resides in the office. It's almost like, Trump being president and then Biden being president, right? There are certain powers that are in that office and that transfers with the office. If that trustee says, you know what, I don't want the person after me to have access to the communication I had with the lawyer, trustee has to pay it out of his or her own pocket. So it's very important if you want to preserve that privilege. Maybe there's a dispute with a beneficiary. Who is the next trustee in line? And if you're a trustee and you're worried about being removed, or maybe you're like, I am so over this, I just want to resign and be done, and that next person steps in, they're going to see all that attorney-client communication. So very important to be mindful. And, if you pay from your own funds, then you maintain that attorney-client privilege. So a little bit of nuance there. In this world, nothing can be said to be certain except death and taxes. So tax reduction strategies, right? This is one reason to engage a lawyer. And actually, there's a lot of tax planning that can be done after somebody passes away. So a lot of people don't realize this. So yes, there's a lot of tax planning that's done before death, but there are tax planning strategies that can happen after death. So one is the use of tax exemptions and credits, right? So you can leave over $12 million tax-free right now, and you would want to take advantage of that, right? Versus not taking advantage of it. There's the unlimited marital deduction, meaning if you're married and a U.S. citizen, you can inherit an unlimited amount of money free of any taxes. And the big one is portability. So this is where if one spouse passes away, the surviving spouse can inherit that deceased spouse's coupon, which is now over $13 million. So that when that surviving spouse passes away, they add the $13 million to his or her own, right now, $13 million exemption, but it's going to be cut down to $7 million in 2026. Here's why this is important. If you have a $10 million estate and your spouse dies and you do nothing and you live past 2026, that could be over $1 million in death taxes. If you file for portability, it eliminates that tax bill. So let me say this another way. If you've lost a spouse, really be mindful of this. Or maybe if your mother or father has passed away and you've got a surviving parent, and you would say, well, gee, you need to file that for portability, which is the way to inherit that death tax coupon is really what it is, the ability to pass money tax-free. That's something that happens only after somebody passes away. And I will tell you, I talk to a lot of lawyers who say, well, I don't think it's a really big deal. I really don't bring it up with clients. I think that's malpractice. And if you're an attorney watching this, we have no idea what the future of the death taxes will be. They could be really generous in the future. They could be really stingy in the future. When I started practicing, you could only leave $600,000 free of estate tax. When I look at the amount of federal debt, and I look at California now is having a hard time getting enough money to keep the lights on. I think taxes are going up. I'm not hopeful that they'll go up, but I don't see how we can cover the government's expenses without increasing the tax burden. And if you look globally over the last 4 or 5 years, taxes are on the rise. So this is not just the United States, but it's global. So I would say if you can pick up that portability exemption, definitely pick it up, because that is something that's that extra coupon. And if you're that you definitely might need in the future, or your family might need. So what does a trust administration lawyer do in California? We are working to help prevent reassessment of real estate property taxes under Prop 19. So this is another big one for clients. When a person passes away and the property goes to somebody other than a spouse or a registered domestic partner, that is a change in ownership. What does that mean? That means your property taxes can go significantly up as of the date of death. So this is another reason to hire a lawyer. Is, let's say mom and dad die and the property taxes go up, but you don't know, and you just sell the house and distribute the assets, you're going to get a supplemental unsecured bill maybe 10, 11 months later, and it could be in the tens of thousands of dollars, depending on how big the reassessment was. And that's just between the time mom or dad died and you sold the house. So we see those supplemental unsecured bills, a lot of money. You are precluded, unless you have a refunding agreement, you're precluded from going back to the beneficiaries, people to whom you've distributed the money, to get that money back. You just can't do it under state law. So this is really important to pay attention to it. This is a very highly specialized area. Very few lawyers understand property taxation. Very few trust and estate lawyers understand property taxation. It's a big strength in our firm, and it's something that you should be paying attention to, because those taxes reset as of the fair market value. So we have an example here, a property that is assessed at $200,000, but has a market value of $750,000. When mom and dad are alive, the taxes are about $2,700 a year. After mom and dad die, they're $8,200 a year. So they go up. Who pays that difference? Well, the trust pays it, right? But if you sell the property, maybe a year later, and you don't hire a lawyer and you don't know all this stuff, and you're the trustee, you're going to get this bill for $6,000, and you're going to be stuck with that bill because you can't go after the beneficiaries to get the money. So we do, in this case, this is a family home or family farm. There are many things you can do to eliminate this reassessment. So this is why it's important to work with an attorney. There are time limits on this. And this would be another reason to hire a law firm such as ours to help you with this. So these trusts are administered in conjunction with the family's existing advisors. And these are going to be the financial and typically the CPA. So we typically work with your existing, if this is your estate plan and you pass away, we typically work with the existing financial advisors and CPAs and other legal advisors. So many times we're the estate lawyer, but they might have a business law attorney. There might be some other type of attorney involved. And these can be very complicated, especially if you have family businesses and investments. And so we typically work in conjunction with them, representing the trustee. Again, it sort of reduces the lift of the trustee or the scope of the trustee's work. So getting an A team together, you absolutely want to assemble your A team. This would be your estate planning attorney, which would typically, that's our firm, and CPA financial advisor. If your estate's over 10 million, if you're married, or 5 million, if you're single, you might consider some advanced planning services. What about IRAs? So this is very common for people to have large IRAs and 401ks. This is a very big tax hit for many people. IRAs do not pass through the trust. Trustees really have no role in this, frankly. It's the beneficiaries. So people get the property. So if I have an IRA and I leave everything to my 3 kids, they're going to have to figure it out. Not a lot of guidance. There are a lot of deadlines. So things have to happen by September 30th of the year following my death, October 31 and December 31. If they don't happen timely, then there's some penalties in there, and those kids might have to take the money out sooner. Many of our clients leave IRAs to an IRA inheritance trust or IRA Legacy Trust. That way there is a trustee who makes sure these time deadlines are met. So that's sort of the use case. If you have a larger IRA, I would say if it's over a few $100,000, you might want to look at this, because if you miss these deadlines, you can have some penalties. But taxes are crazy on IRAs. I'm assuming this is a taxable estate. Bob may have a $30 million estate, $20 million estate. If he has $1 million IRA, $941,000 in taxes. This is not a misprint. Okay. It's because the full $1 million is included in Bob's estate. His kids don't have to start withdrawing. Well, they don't have to withdraw the full $1 million if they play it right. The soonest they'd have to withdraw it is within 10 years, but you're paying death tax on the income, on the future income tax. So this is a real raw deal. So you read this right, 59,000 out of $1 million actually goes to the beneficiaries if you really screw this up. So this would be, again, a use case for having an IRA Legacy Trust or IRA Inheritance Trust and a trustee, because a trustee can make sure that you minimize or you defer as long as you can those income taxes. And this would also be Bob. Bob probably should have done a Roth conversion to pay the income tax, even though that income tax going to the government, the kids aren't taxed on that income tax that is going to the government. So RMDs, generally speaking, all the money has to come out within 10 years if you leave an IRA to somebody other than your spouse. There is a 5-year rule, which is a 5-year penalty box. And that 5-year penalty box, basically, if you screw up, it comes out in 5 years. If you inherit $1 million, you would definitely want to wait 10 years or not. It depends. It depends on what your tax bracket is. This is why it's good to involve the lawyer, the CPA, financial advisor, and IRAs are very very tax sensitive. We've had 2 big acts. The Secure Act 2.0 has really changed the landscape on IRAs. So these are more complex issues. The reason I'm bringing this up is many of our clients have an IRA Legacy Trust that appoints a successor trustee. That trustee absolutely should get legal advice and some good sound CPA and financial certified financial planning advice, because these 3 professionals coming together know what the rules are. If you're watching this, this is something you might want to screenshot, because this is the breakdown of all of the beneficiaries. And the reason for me putting this up here, this is very complex and it depends on a lot of different factors. And really, we have to go case by case, client by client to figure out the best strategy for that. So if you've got an IRA over $1 million, definitely be looking at this. So you can think of the trust administration lawyer as the trustee's wingman, right? Or if it happens to be a woman, wing woman, I guess, wing person, distributing assets and information to the proper beneficiaries as quickly, as efficiently as possible. It's really what a trustee should be doing. Get this thing done quickly. That wingman helps interpret the trust terms, helps provide beneficiaries with notices, working with the accountings and managing disputes, and guiding the trustees. So some of these trusts just kind of continue on. They don't necessarily end. What do I mean by that? Well, there may be something called a subtrust. Now, this may be getting a little granular, but your living trust for many of our clients, look, I have 3 kids. My trust says that when my wife and I die, this goes into 3 trusts for our kids. Each kid has their own trust to protect it from future ex-sons-in-law and ex-daughters-in-law. So that's a concern of ours, right? So this is what's going on here. And in this case, we've got John. He wants to leave $500,000 to his financially irresponsible daughter, Sarah. He creates what is called a subtrust. So Sarah's getting $500,000. The trustee administers this for the benefit of Sarah, the daughter. This really necessarily involves a lawyer. You really should not be doing this on your own. These are complex, and you need to do it right. If you do it wrong, Sarah can sue the trustee, right, for all the stuff that the trustee should or shouldn't have done. So any misstep is 100% liability. So do you need a trust administration lawyer or attorney? Without professional help, I think it's easy to improperly account for assets, not follow the trust, the statutes, the case law, the doctrine, unwittingly create tax disasters, and mess up the chain of title in real estate by failing to make proper distributions by deed or no deed at all, right? Not only are you going to spare yourself enormous hassles, but you're going to protect, the idea here is to protect yourself from that 100% personal liability if you are the trustee. So we're going to cover questions in a little bit. Our offices are located in Northern and Southern California. If you're watching us on YouTube, please give us a thumbs up and subscribe to our YouTube channel. Tomorrow, if you're watching this live, is your trustee prepared? we're having a live Q&A online event with my two law partners, Rochelle Lee Warner and Tasha John. They will be answering all your questions. We have a lot of people subscribed on this one or have RSVP'd on this one, so it's going to be really exciting. Next week is housekeeping items for your financial health, which is not January 4th, 2023, some later time, and you can put that in the chat, Ashley. But this is with Ascent Wealth Management, some certified financial planners at Ascent Wealth Management. And really pay attention to this, because I was talking with my wife the other day, and she says, you know, I don't know what would happen if something happened to you. Like, is everything set up? Like, where is everything? This is what we're going to be talking about, like making sure you're getting your financial health checkup here in 2024. So we'll talk about those things, and we will open it for questions. If you're watching this on YouTube, just go ahead and keep watching. It's going to roll to another video.